Welcome to the Parent Advocate Network. This is June 10th, 2017. We have two people in this room. Hello. And we have three other people who have joined the call. Thank you all for joining us this evening, and we hope to create a good discussion forum here on ways that we can protect children and families all over the country in a peaceful manner. Absolutely. So this is Misty. Hi. And I'm Lyra. And we're here to open this forum for people to discuss what they see going on and what kinds of suggestions you'd like to offer for parents who are fighting against CPS tyranny and those who have not yet been involved in any cases, but very possibly will in the future. We want to stop this from happening anymore.
Definitely. Does somebody want to introduce themselves and say who they are? You're welcome to take off the, if you want to stay, there's a line through the video. That means you're not on video. It should be the bottom left-hand side of your screen. If you want to undo that and be on the video, you're welcome to. So far, this is just for us. You know, here, this is just a meeting for us. But Lyra did start recording, I believe. So it is being recorded, but so yeah, whatever you want to do. I can tell that all of you are unmuted, which is just fine. And you know, the first gal that was here, if she wants to start, you're welcome to now.
Hennie, I believe is who is the first caller, right?
Me?
Yeah.
Okay. Well, I'm Hennie, and I work for Wings for Justice. So.
Wings for Justice.
Yes.
And it's
and
Hennie?
What?
Your name is Hennie, Hennie?
Yes. Yes.
Okay.
It's Hennie.
And IE. Nice to meet you, Hennie. Thank you for joining us.
Nice to meet you.
Yeah.
Thank you.
Very much. Very much.
So please tell us about your League of Justice, League for Justice.
Wings for Justice, we help the mothers who come from abusive situations, and then they lost their children to abusers. And then what we are trying to do is to help the moms to get emotional healing and to get help with all the court things that's happening.
Great. So, do you do that like is it like a one area where you're doing that? Is it how big do you know what I'm saying? Is it like a home or that you're doing that in, or is it bigger than that?
Yeah, it's the CEO lives in California. And then what we want to do is start a Wings for Justice in every state.
Yay.
And then train people locally so that the women, and they also help men, so that people can get locally the help, so that they can go have a place where they can get emotional healing, because that's really important, and that they also get help with all the court stuff. And then they don't have to go and search on the internet or Facebook and find a group, but then it's right there where they live.
Ooh,
so
wonderful.
We're planning on doing training, and then we want to go to other states and train other people so they can train locally.
That's wonderful.
That sounds lovely. We need more of you out there. We are happy to be able to help you in any way that we can. Thank you.
Thank you.
Do you want to leave us with any contact information, like if somebody is in your area that needs some help, how they could get a hold of you? Or we can do that on this call too, however you prefer.
Yeah, they on the website, they can apply. So if they want the help, but they also can contact me.
What is the website address that you have for that?
If you Google Wings for Justice, then you will see the organization, and the CEO is Wendy Miller. So, and she also has like a video on YouTube about what happened to her. So,
okay, great.
So,
yeah, this is just about that. I've had 2 calls so far today of people who could have, maybe I need to talk to you.
yeah, because we want to really help.
Send them. You know, how do I get the information that they're looking for quickly? So this is great. Thank you for joining us.
Ask and you shall receive.
That's right.
All right.
Anybody else?
Anybody else like to introduce themselves this evening?
Well, this is Brian Spencer. I'm calling in on behalf of the JAM from Ohio. And we believe that, most parents have a right to have access to their children. In the absence of finding of unfitness, abuse, or neglect, there should be an automatic presumption of 50-50 custody after the court's involvement, and there's a finding by clear and convincing evidence of abuse, neglect, or dependency. Can there be any infringement upon those rights?
I agree. I agree. I think that should first and foremost fall on the parents to direct the care of their children, no matter what's going on, and where they're going to be while situations are being addressed, if necessary. And so that's where I'm at. The 50-50 custody gets a little confusing. I know I was trying to work that out with mine, and because it's something really tricky about it, but I want to find out more about that and what that all entails, what it means for decision making. And sometimes you have somebody who's just wants to be irritating and wants to get in the way of your role, and wants to just make things difficult. But gosh, thank you. And you're in Ohio?
Yes, ma'am.
And you're with JAM, you said? JAM?
JAM, the Judicial Accountability Movement. Everyone else is, I have full custody of my children, and I am a single father, but I'm sitting and I'm saying, it took me 8.5 years to combat against false allegations. And, I keep telling everyone, going back into the court system is a lesson in futility. We've all been programmed to believe that it's within the halls of justice that you're going to obtain some relief, when the harsh reality is that once as you embark upon the journey, you discover that those that sit in those positions to adjudicate matters abuse you more than what your ex ever dreamed possible. So, we're moving forward right now. I'm working with a number of boards, but we're preparing to take legal action into the world court because we believe that the facts and the evidence clearly illuminates that the judiciary is a self-serving mechanism or organism that doesn't operate for the best interest of these children. They simply operate for whatever's going to generate more revenue for the courts.
Exactly. And the point, like, where we want to prevent, because once the damage is done, you're talking about years of recovery and rehabilitation for both parent and child. And so we want to prevent this from occurring anymore and help all those who it has occurred to, and help them find their help, and make people aware. And what was it yesterday? I think I said, don't go into the system unless you have to. And part of what I want to do is bring forth awareness to parents and offer a mediation, another way to just stay out of the courts, save your money, It's really bad right now, and we know that. But I think it's getting better. I really do believe that it's a matter of the people making their decisions, but all they have to do is change their minds and be held accountable for what they're doing. And I know there are good people working in the systems.
We have plans to be publishing a parental rights pamphlet for each state in this country, and also direct them to a site that will send them a free booklet of the Constitution of the United States with the Bill of Rights in it. And there is another movement by parentalrights.org that is pushing for bringing a law for parental rights into the United States Constitution as one of the Bill of Rights, so that we have a permanent security of being parents and being able to parent our children as we see fit, as we were supposed to when we were given them as a part of our responsibility. And so that's another part of what we're trying to do, we want to do in order to stop the children from being removed in the first place.
Thank you for being here.
Thank you
Thank
so
you for
much.
being here. Okay, we have one left. Who's next? I recognize that.
My first name is Lamaina Hennie. I'm part of Raise Your Rights, and our group has introduced a California ballot initiative to allow parents the option to a jury before parental rights can be taken away, either in a divorce situation or in our case it's called CPS, or if CPS has taken temporary legal rights to a child, that before their permanent legal rights can be taken away, that they do have an option for a jury trial. There's 5 states that allow jury trials before parental rights can be terminated, only in dependency court. In our case, it's CPS. I think some of the dependency court family services, as they call it, are DCS, DHSS. We've seen all sorts of different names across the board for all the different states. And so these 5 states that allow jury options, out of them 4 actually protect a parent from losing legal rights to their children. Texas is one of those. But none of those states except for Texas allows a jury option for divorce cases when a parent's trying to take away legal rights to a child from another parent. And we've heard all the mediation and the advocacy and the nonprofit mediation groups. And the problem is, in a lot of divorce cases, one parent wants sole legal custody of a child from the other parent, and all the states say, no, it's supposed to be 50-50. I know lots of groups are getting laws, at least bills. I don't think any laws were passed, because I think what happens is these bills get introduced for shared parenting or 50-50, and they go to the legislature for that state, and the state says, well, we already have that. We have some sort of bill that says something about no preference for mom or dad or anything like that for shared parenting. And as you and I know, and everybody else knows, that every parent's going to fight for more or less than 50%, so that, number one, they don't have to pay child support, and then number 2, because it's their child and they want to have more time with them than the other parent. And then, of course, there's lots of other reasons as well. So while those things are great, and I think people should be working on it, I don't think that changing the laws for shared parenting or any sort of non-presumption of a mom being a better parent than a dad, which I don't think there are any in any state, and you can correct me, but I don't think there's any presumption that a mom makes a better parent than a dad. The bottom line is, what we're trying to educate people is that the bottom line, it always comes down to a judge in your state and your county. So what we've been trying to do, and Hennie, if you're still on the line, we've been communicating all day. We've been trying to join our different state groups together, because I think we all, from listening to everybody has an idea that we need to be in the states because these are all state rights. So we can try and change the federal government, but the Constitution, the federal government will not touch child custody issues or child visitation issues. Those are state rights. You would have to undo the 10th Amendment. I mean, even if you tried to change the Bill of Rights and add in some sort of parental rights, they're state. They're not federal rights. The only federal right is that a biological parent has a constitutional right to the familial relationship. But the states can overcome that. And I know that I've had people that said, we need to abolish Title IV, we need to abolish CPS, we need to abolish all those types of agencies that go in and misuse their power and take children away from good parents and then make all these false accusations. And what we always tell them is, and we try to educate them is, well, it always comes down to the judge. So a judge can hear false facts, say that they're real facts, and there's really nothing you can do about it, and they can terminate parental rights. So we're trying to educate people that everything comes down to a judge. We're trying to join people in states because it's the states and the counties that elect these judges. And then what we're also trying to do is also advocate for divorce courts, because what's routinely happening now in many, many situations in many, many states is that the parents are routinely denied legal rights to a child so that the court can save money. And so those parents now left with no legal rights to the child. And when they step out of the courtroom and they try to enforce their visitation rights that the judge still gave them, even though they don't have any legal rights to the child, is that it becomes virtually impossible and contempt charges don't work. So what we want to do is prevent all of that from happening on the judge level, that a judge can be circumvented with a jury option so that a parental or a parent's rights are not terminated. Texas currently does offer that right, and jury trials are rarely used in Texas. And I don't think there's anyone here from this group from Texas, but if you listen to the Texas parents complaining, they're basically all complaining that they didn't get 50-50 and that one parent has to pay support and that it should be equal support. Of course, there's lots of disagreement about that because it's really the child that's being supported, not the other parent. And so if one parent's better able to afford child support than the other parent, then I don't think you're going to get any legislature in any state to agree that both parents should pay 50-50% support for the child. And the arguments in Texas usually revolve around the fact that, oh, I only got 46% visitation rights and my spouse got 54%. That's not fair. So we basically try and ignore those conversations, to tell you the truth, because the rest of the country, as I think all of you know, have parents left and right in divorce cases and CPS cases that no longer have legal rights to their children because of a decision the judge made, and then they no longer have rights to visitation with their children because it's almost getting impossible to get anybody to enforce visitation outside of a courtroom. And these kids are being erased from a family member, or even worse, the entire other side of the family. And of course, the devastation there is, like you said, it takes years and years to fix something like that in a child's life, if that's even possible.
Yeah, and it's not just the child and the parent, but it's extended families, and like you bring, it's really the whole community that suffers every time this happens. And there's other ways. It almost doesn't matter what's going on. When you do that, it's worse. It's worse than whatever was going on.
I just wanted to point out that there is actually, for parents who are involved in CPS cases and have been accused of a crime, you as a parent have the right to request a jury trial, because a crime, if you are being accused of a crime, you either have to be arrested for that crime and then they have to show proof of that crime, or if you're accused of a crime, CPS still has to show proof of that crime. So if it is abuse or neglect or some other crime, those are not, the family court is not able to deal with those cases. They have no jurisdiction whatsoever, and you have to be firm in telling them that you need to have a jury trial. You want to see your accusers. You want to see the evidence against you, and do not plead guilty or even agree to any deals that any lawyer may be presenting you with before a jurisdictional hearing, because you have rights.
Well, here's what I think most parents don't realize with CPS, and we actually had a constitutionalist today that we had asked questions for, and she ducked the questions regarding family court. But so basically, the district attorney in your county decides whether or not you've done something criminal, and even if you have done something criminal or not against, the people of the county, then the district attorney office gets to decide whether or not they're actually going to prosecute that criminally. And routinely now, especially in our county, our district attorney is routinely not prosecuting what are clearly acts of domestic violence. And the reason that they're not is they then send them to family court. Well, in family court, there is no right to a jury trial. So basically, we had an NFL football player beat up on his girlfriend, and the district attorney's office decided not to prosecute it and sent it to family court. Well, in that case, he doesn't get a right to a jury trial, but she also doesn't have any rights. She couldn't afford an attorney. And in a district attorney's office in a criminal case, they are the attorney. You as a victim do not have to afford an attorney. So what happens routinely with CPS cases is they think they have a jury trial, but the only time that they have a jury trial is if actually criminal charges are being pressed against them. And then that has to be resolved first normally before it then moves to civil court. And most of these CPS parents don't realize it, but they've already seen 2 judges by the time their parental rights are taken away. And even if they're found not guilty in a criminal court, it still will go to a family court judge or dependency court judge. In a lot of our counties, it's the same judge. And then that judge will still take parental rights away. So they have to know their rights. And I think a lot of these CPS parents don't understand their rights. And number one, if they think they've done something criminal or being accused of criminal, they have to find out if the district attorney's office is actually going to prosecute them. And if not, then it's no longer a criminal matter. It gets moved to civil court. And then if they're not in one of those 5 states that have jury trial options for civil matters, then they don't have a right to a jury trial. So I've heard some parents are waiving their rights to a jury trial in a civil matter. They haven't been accused by the district attorney's office, and they're waiving them. And I'm saying, what are you waiving? You don't even have a right to a jury trial in your state in a civil matter. And I think what they're doing is they're having them waive it anyways. Because, and I asked her that question today, because in California, it's in our Constitution that for civil matters, like if someone steals something from you or they breach a contract with you, businesses can have a jury trial in civil matters in almost every state. In fact, every state has a jury option for civil matters, except for termination of parental rights. So that's what our ballot measure is. It's just simply changing the law in California for jury trials, where it has a long list of things that you can have a jury trial for civil matters in California, but losing legal rights to your children are not one of them. So our ballot measure adds that option on. It's very simple. The problem, of course, is that we still need a senator to put it through our legislature. Otherwise, we have to collect an astronomical amount of signatures, wet signatures.
Now, I remember reading an article from 2015 that Kamala Harris, when she was Attorney General, had very clearly stated that in her dealings with foster children, the family courts, that she discovered that there was definitely evidence of clear discrimination against parents in California CPS cases, and there's a lack of services that was clearly unmet, and that she created the Children's Department of Justice. Now, do you think that she might be willing to sign on for this?
She's in Congress now. She's no longer our Attorney General.
I know, and she's our senator now, though.
But see, now the problem is she's in the federal court systems, and parental rights and children's rights are a state issue. So while she may support it, I don't know that she has any power to change it. She's no longer in the state legislation or as a state attorney general. But I do appreciate her efforts, you know, and I watched her get reamed in the federal court system because she's a pretty aggressive lady. But I think that we lost her. So, and I think you're right about CPS. Nobody denies that. There's lots of CPS workers that are coming out and saying, hey, this is a business. If we don't have kids, then we don't have a business, and we don't want the hard kids. So when there's really a serious CPS case, it's really interesting or horrible, whichever way you're looking at it. From our point of view, we're just shocked that there's certain cases where they should interfere. I mean, I don't think we can abolish the government from stepping in to protect children in a lot of situations. We do need to have that service. But what they're doing is they're actually not even picking the children up that they should be providing services because they're so damaged or they're going to cost so much money or that type of thing. So to perpetuate their business, they're not even taking the kids that we're paying our tax money to protect. They're taking the kids that we're saying, hey, no, these kids belong with their families who love them, not with strangers who don't. And it's just a horrific situation that's been caused. And I'm sure she saw it and wanted to change it, but I don't think she made any real changes, and I don't think she can anymore.
Well, once you have appeal in family court, your appeal, if it's for the judicial misconduct or any of that stuff, it goes to federal court in Washington.
No, what happens is there's a court order made by a judge in a state court, and if it's a factual finding, which almost always is in CPS cases or in divorce cases, the judge will make a factual finding that this parent should not have legal rights to the child, and you can't appeal factual findings. It's almost impossible because the judge gets to decide if you're...
I dropped out. Right. I didn't let him decide it. I left before it could be done. So I wonder if that is interesting. Gosh,
you can appeal. Yeah, you can appeal findings, but it usually has to be that the judge made a mistake of law, or a procedure, or lack of jurisdiction, or something like that. Then maybe the appeals courts will hear you, and you can go all the way to the top. But that's as far as you can go, and then you have to go straight to the Supreme Court. Now, if you go into the federal courts, and I know a lot of people are going into the federal courts, which is great, you're going to get hit almost immediately by what's called the Rooker-Feldman doctrine. And what that is the Fed courts will say we don't have jurisdiction. This is an issue that the states have jurisdiction of. And they'll dismiss your case. And what's happened really recently, as we all know, in Orange County, and there's 2 or 3 other cases, is the plaintiffs are saying, yeah, you know, we understand this is a state issue, but the state committed fraud and took away my constitutional rights. And now the federal court is saying, well, that's a whole other issue. Then we will take jurisdiction. Yeah. So even though it's a state issue, right, but you have a federal constitutional right to be with your family, and the state committed fraud to take away that right, now we'll hear it, and you can overcome the Rooker-Feldman doctrine. But I see a lot of people going into federal court with, you know, the judge did this, the judge did that, the judge should pay for this, the judge should pay for that. And that's not going to happen. And like we've been trying to, you can probably see us, we're trying to inform everybody, judges have absolute immunity. You cannot sue them for money, and you can't make them change their decision in a federal court system. You can do it in a state court system, but it's a very narrow thing that you can make them change your decision for. And it's not factual findings. It's like legal jurisdictional.
Could I weigh in for a moment?
Ahead. Please, yes, please.
Okay. If I could weigh in for a moment, okay. First of all, I want to add a few things in here. Number one is that you're saying that this is a state court issue and it's not a federal issue. Number one is that under the Constitution and Declaration of Independence and the Bill of Rights is that you have a God-given, protected right and an unalienable right, which means that it can't be bought, it can't be sold, it can't be traded, it can't be given away. It's unalienable. And the court has no right, absent the finding of unfitness, abuse, or neglect, the entire system on every state and every state statute that regulates child custody has to be deemed unconstitutional on its face. You cannot enlarge one parent's access to the children while diminishing the other parent's access to that child, absent one of those three findings. Now, when you take and you say about the Rooker-Feldman doctrine, that was narrowly defined in Caperton versus Massey, and what the parties allege, because I've been to the U.S. Supreme Court, and I have ultimately prevailed, and I've got full custody of my children. But one of the arguments is that the state court constantly comes back, or the federal court comes back, and as you clearly illuminated, saying that this is a state court issue. Well, then if it's a state court issue, explain to me why it is that we are utilizing federal incentives by funding a state court matter. You cannot have it both ways. And under Public Law 104-193, the state has certain prerequisites that has to be mandated and met in order for the state to receive that Title IV funding. If the state is negligent in their obligations with the compliance with the contract in which they agreed to accept that Title IV money, then it's void and null and it has no effect. So, you know, I think that there's a lot of areas there, but I think one of the biggest problems that we've got, and you say that judges cannot be sued for financial damages. Well, now let's go back and review that, because absolute immunity was never passed by the legislation. It was a self-imposed mechanism that was put in the Stumps versus Sparkman case, and whereas they had made a determination that they could not be sued. And at the same point in time, there's a lot of arguments going before the U.S. Supreme Court right now on the violations of law being committed by the very system designed to ensure to uphold the law. You cannot take and go to a judge, and as you clearly illuminated, you go into a trial court, you see a judge, and then if that judge makes a decision, and it's supposed to be predicated upon the precept of a factual evidentiary hearing. However, if the judge omits or embellishes some of the findings in order to derive at their conclusion, then those things can be challenged within the federal court. Now, I know myself out here in the state of Ohio, I had to take and go to the effort of taking and having the judge served in an open court proceeding by the U.S. Marshals and shut down the whole damn court with a federal filing accusing her of aiding and abetting in parental alienation. And that case went on up before the U.S. Supreme Court. The U.S. Supreme Court ultimately came back and denied it. We went back in, we argued it again. And then the state court, the federal court, had issued an unpublished opinion giving the state court the directive that they needed to resolve the issue. Well, the only way that the state resolved the issue was the state gave me back custody of my children. Well, that's just peaches and cream and oodles and kudos, but it doesn't erase the 8.5 years of hell and torment and grief and aggravation and financial devastation in which the state caused. So now we're going back in and we're suing the judges again, because Justice Scalia in his decision in the U.S. versus Wells said that there is no such thing as absolute immunity. Immunity, if any, can only be limited or qualified. It has to be determined upon the facts and the evidence presented at trial. The problem is that you're going to the court and you're asking the court for a trial against one of their own brotherhood, and they are reluctant in giving that. So what I had suggested today to the Law Project when we were on a call with them, and it's not only in the family law matters, it's also in the probate division, it's also in our criminal matters. We can see the making of a murder, we can see the proliferation of abuse being delivered at the hands of the judiciary, and we're saying, listen, when you take and you collect the data, and we have 1,086 cases that clearly solidify the argument that the U.S. Supreme Court established in Chickamauga versus Basumino that the highest court in the land is the court of record. Nothing speaks louder than the court's own record. So when the court's own record clearly validates and verifies each and every single allegation which a party alleges, then there can be no court above or below that can undo the unjust that was delivered at the hands of the very system designed to ensure against it. The only action that you have is a tort claim action in front of a jury of your peers to make a determination upon the amount of damages that was inflicted by the hands of the judiciary. And I've been to see Senator Rand Paul. We've been to we're right now scheduling an appointment with Craig Gotti. We're working with the scheduler on that, trying to get an audience with him, because we're saying the whole thing, and it was forewarned by Patrick Henry when he said that the greatest threat to our nation will be the unbridled checks and balances on the judiciary, where they'll steal a little here and a little there until one day we live under judicial tyranny. And that's where we're at today. They have to be brought into check, and I disagree with the fact that you cannot hold a judge liable for damages. If that be true, then explain to me why here in the state of Ohio, Judge Squire was sued, and Judge Squire, the state ended up paying out a $3.2 million judgment on that case. Every case has to be viewed on its own merits. And I think that there's precedented argument that today's judiciary has been run amok. That's just my own personal 2 cents. I think that, we have to look at for the best interest of the children. I concur with your sentiments on, that we have to have a mechanism in place for the protection of our children. But I think that it has become blatantly obvious that it is a money-making scheme. If anybody watches the documentary the documentary Divorce Court put on by Joe Sorge, it's a $50 billion a year industry. That was documented in 2012. We're now at 2017, and by the latest statistics and data that I've seen, and I'd have to go back and find out where they were, but we're now approaching $88 billion. It's a constant racket. And yet the court sits and they perpetuate this nonsense that when you go in, that, and they take your rights away from you, well, then it's obviously because you have an anger issue. Damn right, you're going to be angry. If somebody terminates your right with no finding of unfitness, abuse, or neglect, the state had no right to intervene with your familiarity relationships. So I just think that the timing is ripe. I think the people is ripe. I think that the climate's ripe. And I think that this will be the next larger than the civil rights movement of 1964. That's what I believe.
Let's see.
Well, Judge Squire wasn't actually the one who had to pay the money back, and it was the state that was sued. And in the Orange County case, it's the county that's sued. In California, to sue the state or the county, you actually have to go through the permission process in order to sue them. So,
right, they come back and say that they have an 11th Amendment right. Okay, that you can't sue the state, you have to ask their permission. But then you can take and fast forward, and you can switch gears and look over at what Pam Gaston did there in Mount Airy, Oregon, and she got a $500 million judgment against a judge, against the CPS workers, and against the police department there in Mount Airy, Oregon. And, what people don't understand is that was a jury trial, which means that it was non-reversible. They couldn't change what the jury had awarded.
Okay, but in those cases, the judge is not the one being sued.
The judge was held liable in Pam Gaston's case. He was held financially liable.
Mike, everybody, we would like to please bring it to your attention. We are unfortunately going to have to close this group for a moment because we have to reopen it for the meeting. I don't have the finances to get this call longer than...
It's okay.
I'm sorry, we'll be right here.
And we'll share the meeting on the coalition. This is part 2, and we invite you guys to come back to it. We posted the number here in the chat. It'll be meeting number.
We got muted. We're going to be right back, Alicia. Sorry about that. It'll be the same number unless that doesn't open up, and we'll post it on the coalition, on the Parent Advocate page, okay? Thank you.
Thank you. So just stay in there a second and see what happens.